The appeal court recently ruled no time limit for simple court declaration voiding marriage contract. In a recent and significant Ontario Court of Appeal decision, the legal issue was simple: whether a former spouse could have a marriage contract set aside even though the standard 2-year deadline under the provincial limitation period legislation had already expired. Excuse me. The former couple, who had been living together for a year, had entered into a prenuptial agreement, which is a form of a marriage contract. 1 week before the marriage ceremony, it was drafted based on a template for prenups that the wife had found on the internet. Neither of them have obtained legal advice before signing it. Under the prenup's wording, neither of them could claim spousal support from the other if they separated, and they would continue to treat their property separately, meaning there would be no equalization process. The spouses did separate after 7 years. More than 2 years later, despite the prenup, the husband nonetheless brought a family law proceeding claiming spousal support and for equalization of family property. This prompted a volley of legal arguments and counter-arguments between both of them. First, the wife pointed to the prenup as completely blocking all of the husband's claims he was asserting against her. Second, the husband responded by asking the court to set aside the prenup because he had ostensibly signed it without legal advice, under duress, and with inadequate financial disclosure. Third, in turn, the wife claimed that the husband's bid to rescind the prenup was out of time because there was a 2-year limitation period on bringing such requests, and it had already expired. A lower court accepted the wife's last argument as to the lapsed limitation period and concluded that the husband's claim was time barred. The husband successfully appealed to the Ontario Court of Appeal. The appeal court noted that the 2-year limitation period in question under the Ontario Limitations Act from 2002 was simply inapplicable to the type of proceedings and outcomes pursued by the husband. First of all, his attempt to have the prenup set aside was governed by Section 56(4) of the Family Law Act, which allows for a court to declare all or part of a marriage contract null and void in certain circumstances. His was a request for a straightforward court declaration to that effect, and did not include any application for what is known as consequential relief, such as damages or other remedies needed to achieve justice. Such requests for court declarations where no consequential relief sought are simply not subject to any limits at all under the Limitations Act. The husband's claim for spousal support fell under the Family Law Act and was not subject to any deadline at all. His claim for equalization was governed by the 6-year limitation period stipulated in the Family Law Act, which had not yet lapsed. After a careful reading of the Limitation Act, it yielded no authority or reason to trump those outcomes. As the court observed, these special limitation periods account for the need to allow spouses more time to try to resolve the property issues without having to go to court. And the fact that a spouse or former spouse's support needs can change over time and may be addressed whenever they need to. The Court of Appeal also noted that the combined operation of the Family Law Act deadlines, together with the Limitation Act, which expressly recognizes time limits in other legislation, usually results in family-related proceedings having a more generous limitation period than the standard 2 years. This, the court said, is a recognition of the unique situation spouses and families on the breakup of a marriage. In the end, the Court of Appeal held that none of the husband's asserted claims were statute barred, and that the lower court ruling was to be overruled. He could proceed to ask the court to have the prenup set aside on the merits and for other requested remedies. Please give this video a thumbs up, comment below, and share it with your friends and family. Subscribe to stay up to date on family law and future videos. We'll have upcoming videos on topics such as a day in the life of a family lawyer, as well as Q&A videos where we'll be answering your questions that you submit to us via social media. So be sure to subscribe and hit the bell icon when notified and when we post new videos. Thank you for watching. Until next time, I'm Russell Alexander.